I note this one Alliant case here, this General Services Administration SBD Alliant, not really because it's really not an ethical case or decision, but if you do look it up, it's interesting because I think the decision itself is a reconsideration of a prior bid protest that was filed, and in this case, the bid protest was challenging the award of a contract, and it was sustained, and the Government Accountability Office had instructed the agency to recompete and allow the protester back into the competition to allow them to be eligible for or to pursue the award. What's really interesting about this case is the entire sort of the key argument that resulted in the sustain for the protest was based on a requirement in the solicitation that had been deleted. And neither government counsel, the counsel for defending the award, which we call the intervener counsel, or protester counsel had even seen this information or knew it existed. And so as a result, in this reconsideration decision, it's sort of shame on all the parties for having missed this. And as a result, the Government Accountability Office, even though they didn't change the ultimate sustain of the protest, they did change their recommendation so that the protester was no longer going to be eligible to get back into procurement. So I point this out because if you're representing your client and you do all this work and you charge them for your legal fees and you get a sustained protest and everyone's happy that the contractors can get back in the competition, and then they find out later that ultimately all the parties missed a particular part of the solicitation, it's obviously going to be an uncomfortable situation. Now, this one was actually, and the other piece of this and I'm going to ask George to comment about this now, but I know there was another piece of this, another part of this whole procurement that was somewhat unique and another sort of cautionary tale.
Yeah, so this case is really a great example of how the issues around ethics in government contracting really do apply to different practice areas, because at the heart of the case, it is about what a lot of lawyers fear and what keeps us up at night is, what is our client keeping from us? What are they not telling us? Is something being missed that we just don't know, all the unknown unknowns?